My name is Paul Godho. I am a chartered arbitrator based in Kenya, and I'm also a construction adjudicator. And it's my honor this morning to chair this excellent webinar. NCIA, as many of you know, is involved in all aspects of dispute resolution, including mediation, construction adjudication, expert determination, and arbitration. This NCIA webinar on construction adjudication is particularly well timed for several reasons. Africa today looks like a massive construction site. Airports, roads, railways, other ports, seaports, power plants, transmission lines, and all, including industrial plants and buildings, are being constructed, extended, and renovated. Some of the projects have faced long delays and cost overruns. Then add COVID-19 into the mix, and three things come into play. Firstly, health and travel regulations have disrupted availability and movement of labor, experts, and materials. Then, national priorities and resources have quickly shifted from development projects to survival. And thirdly, the question arises, are the adjudication time limits of 28 days, 56 days, and 84 days still achievable in the COVID-19 era? This makes the need for effective and timely dispute avoidance and management greater than ever before. Construction adjudication is a unique ADR procedure involving exceptionally fast determination of construction disputes. It has been referred to as rough justice, or as Lord Ackner said, it is also a pay now, argue later approach to justice. Construction adjudications take various formats. The solo adjudicator, a panel of 3 or 5, and the name also changes depending on the rules and the circumstances. Sometimes an adjudicator is simply called that, an adjudicator, or could be called a dispute board, a dispute adjudication board, or a dispute avoidance and adjudication board. The main roles of DBs, DABs, DAABs, and DRBs are twofold. Firstly, dispute avoidance, and that is ensuring that situations are addressed fully and satisfactorily so that they do not smolder into disputes. The second is the dispute board or the adjudicator is required to hit the ground running once a dispute crystallizes, and he or she or the panel is required to provide a decision within the stipulated time. The parties and adjudicators work with very tight time constraints and usually on the basis of documents only. Therefore, the only major legal requirement is that the rules of natural justice are observed. An adjudication decision is binding and final unless a party which is aggrieved by the decision refers the dispute to arbitration, but that must be done within the stipulated time. Allow me to mention that dispute resolution boards, or DRBs, which originated from the US, operate slightly differently. They issue an unbinding recommendation, which becomes final and binding if unchallenged by the parties within the stipulated time. Now, construction adjudication in Africa is largely driven by bilateral and multilateral financiers, which prefer FIDIC or modified FIDIC forms of contract. The other thing is that in Africa, I'm not aware of any state which has got adjudication legislation. Therefore, construction adjudication is carried out and enforced purely as a contractual arrangement. Ladies and gentlemen, we have got interesting topics lined up for you shortly, and we have an excellent panel made up of Nicholas Gold, and Nicholas is an international specialist construction, engineering, and energy lawyer based at Fenwick Elliott LLP. Those are solicitors. He is a quantity surveyor and also a solicitor. The second panelist is a Kenyan, Mr. Festus Litiku, who is a quantity surveyor, a fellow of the Chartered Institute of Arbitrators, and a construction adjudicator. The third panelist is from Zambia. He is an engineer and a construction adjudicator in Zambia and elsewhere. So, ladies and gentlemen, I invite Nicholas Gould to make his presentation. He will tell us about two things. Firstly, he will talk about the adjudication process and the application for an adjudicator, and also the enforcement of decisions from contract-based construction adjudication. Thank you very much.
Thank you very much, Paul. Nice to be with the panel today, and I hope everybody out there is able to hear us and enjoy our discussion about adjudication today. So I'd just like to pick up then those 2 points, the adjudication process and applying for an adjudicator, and then think about enforcement. So I'm going to look at this from the perspective of common law, and I suppose I'm going to use my English experience, and then talk about dispute boards and adjudication in Africa a little bit as well. So my work is mostly international, and I spend a lot of time in Africa or the Middle East. But adjudication for me was something I first came across in the 90s. And in England, we had a person called Michael Latham, who was really interested in improving the speed with which disputes were resolved in the construction industry. And he produced a government report, the Latham Report, in 1994. And very unusually, it became legislation. So most government reports don't turn into much. They're good ideas sometimes and don't find their way into legislation. But in 1996, legislation was drafted called the Housing Grants, Construction and Regeneration Act. And in 1998, it became law. And it introduced adjudication into the construction industry, 28 days to make a binding decision. To start with, the industry was, I think, surprised, and no one wanted to use it because they thought, this is so fast compared to going to court or arbitration. It's such a new thing. What do we do with it? But after a few cases, everyone started to use it. It took off once the judges said this process works and we will enforce it. So just pausing there, what is this adjudication process then? Well, is it arbitration? No, it's not. It's definitely not arbitration. So that means it is just a contractual process. Even in England, where there's legislation, there might be legislation behind the construction contract, but all it really does is imply into the building contract the process of adjudication. So the Act says that either party can refer a dispute to adjudication. If it's not in the building contract, it's implied in. You have 7 days to appoint an adjudicator, and there are 28 days for the adjudicator to make a decision. So just pausing there also, it's not an administrative law process. It's purely a contractual process. Now, 7 days is not long to appoint someone, and the industry had to train people and find adjudicators. And where do they come from, and how are they appointed? Well, the legislation simply says that an adjudicator nominating body can appoint, or the parties can agree. And there are about 18 adjudicator nominating bodies in the UK. Essentially, they are the professions. So the Royal Institution of Chartered Surveyors, the Institution of Civil Engineers, the Royal Institution of British Architects, those will all appoint someone if you ask them. But the real key is what the contract says. So the JCT contract, the most widely used, that has a default position of the Royal Institution of Chartered Surveyors. So they appoint the most people. Now, either party can apply to the RICS, pay a small fee, and they normally make an appointment within about 2 days. And this is important because whilst there is 7 days, you actually need the person to be appointed. They need to write to the parties, and then the referral needs to be sent to the adjudicator to trigger the 28 days. So all of the contracts now in the UK have been amended to include that process. More and more, though, adjudicators are appointed by agreement. So sometimes one of the parties will, when they begin adjudication, offer 3 names, and the other side might accept 1 or might offer 3 more names. Sometimes, of course, this means that the parties can't agree anybody, and the best suggestions have already gone, and then they write to one of the appointing bodies. But I'm sure you probably have seen that before. There is also a detailed scheme in England, and this is called the scheme, and it's the procedural process that can be used. Now, there are other rules that have been developed. The ICE has one, the Centre for Effective Dispute Resolution has an adjudication process, and these get included in contracts. But again, there is a legislative background. And so you could just simply say in your building contract in England that either party might refer a dispute to adjudication at any time in accordance with the scheme. And that's all you'd need to say in a contract in England, and it would bring in the whole procedure. So it's quite easy to introduce adjudication. You can apply online, and you've been able to do that for quite a few years now. So even though we're in COVID times, it doesn't seem to have made much difference. People are still appointing online, and adjudications are going ahead. Just going back to 1999, the first case in the UK was called McCobb Civil Engineering and Morrison, and the dispute was related to an interim valuation for £50,000. An adjudicator made a decision, and the other party, the employer in this case, didn't pay. And the judge said that this is a speedy mechanism for settling disputes. It's backed by legislation. There's no final determination here by the adjudicator. If the parties don't like the outcome, they can go to arbitration or litigation, or they can settle their dispute. But in the meantime, they will pay, and it is binding, and they will abide by it. And this was followed by a Court of Appeal case the following year, involving the international French contractor Bouygues, and a similar approach was adopted there by the Court of Appeal. And after that, everybody in the UK began using adjudication from 2000. So for 20 years now, it's become very common. It's been described as a dirty and quick fix to keep the project going. And I know that you've had a similar approach in Africa. And I was reminded of the Radon Projects case, which is a South African case, where Judge Nugent said that it's now become common internationally, and in some countries by legislation, referring to England, for disputes to be resolved provisionally by adjudication. So you have the same contractual approach. And indeed, when I look at other cases, there's the Freeman and Eskom case, you'll see that judges there have been really very good in enforcing this contractual approach. I also noticed that in the early days, if you go back to some of the cases from 2010, they were referring to the Macabre English case and the Bouygues case, and then referring, of course, to the contracts and the rules that you have, for example, the JBCC adjudication rules, and enforcing these decisions. So that, I think, is a really good and interesting position to find ourselves in. And if you were to look also at New Zealand, Australia, Singapore and Malaysia, they've all adopted an adjudication process. Those are legislatively backed, but I don't think it's necessary, providing the contract is clear. Just to focus on a couple of points about the process, we've had lots of cases in the UK, and one of them called Carillion Construction and Devonport. In that case, it's a Court of Appeal case from 2005. Judge Jackson set out 4 main points, which I think are true of all of the adjudication processes. And the first one was that it definitely doesn't involve the final determination of anybody's rights. So you can always carry on if you want to. But secondly, that the courts will always enforce a decision. So regardless of any errors of procedure or fact or errors of law, that decision stands and you pay now and you argue later. Thirdly, if the adjudicator has acted in excess of their jurisdiction or there's a serious breach of natural justice, the court would not enforce it. So the court will always check to make sure that the adjudicator had power to make a decision and didn't lose that power along the way. So an example of losing the power along the way was referred to in one of the cases, another South African case called Trencon Construction. This is 2017. The judge was DeVos, and he was the judge was concerned there about the Aldi Alterum Partem rule. This basically means the ability to listen to the other party. And this is one of the things to remember about a 28-day or a 56-day or an 84 dispute board process is it's fast. But if you're an adjudicator and a party makes a submission, you still must always give the other party a chance to comment. You need to make your decision based on what both parties have said, not just weigh up what one party has said. Now, in that Trencon case, the decision was enforced and there was no breach there of natural justice, but it just reminds us that you must always think about that. And then finally, the last point, going back to the Carillion case, was that the judge said that when a judge is thinking about enforcing a decision, they must examine any technical defenses with some skepticism. In other words, there probably will be errors of law or fact or possibly procedure by an adjudicator where one person is having to do so much so quickly. It's not like a judge or an arbitrator that has much more time. And so the idea really is that it's only quite excessive jurisdictional breaches that would mean a decision is not enforced. Otherwise, a decision should be enforced, and then the parties, if they don't like it, can go to the court again or to arbitration. Now, in the UK, there was some research carried out some years ago by one of the universities in Scotland, and they found that only between 1% to 2% of the adjudications that were held went on to either the court or to arbitration. In other words, more than 98% just accepted the decision, paid and moved on. And out of those that went on to a further process, the research that they had, it was a bit anecdotal, but it seemed to suggest that in most cases, the arbitrator or judge came to a very similar decision. So it just makes you think, doesn't it? If you spend a month or 2 or 3 reaching a decision compared to a few years, it may be that the decision is no better for spending all that extra time and money. Anyway, so then just a brief recap. The adjudication process then, certainly in England, is 28 days. But once you leave the UK, you find different processes. And FIDIC provides a 56-day under the old 1987 1995 option for dispute boards. And then from 1999 onwards, and still in the modern 2017 contract, so an 84-day process, all supported by contract, and as we can see, regardless of legislation, supported by the courts often and arbitrators. So when it comes to enforcement then, just to conclude on that point, you might be looking to the court for enforcement, and from my African experience, I've been really encouraged by the excellent support that the courts have given adjudication. Or you may have to go to arbitration. Of course, if your contract provides for arbitration, you probably need to go to arbitration and then ask the arbitrators for a final but interim award in order to go and enforce that DAB decision. And we've had mixed responses around the world in relation to that. There's some interesting cases in Singapore where the judges struggled for a little while to decide what to do, but eventually concluded that they must enforce immediately an interim award. So sometimes it can take a little while, but at least we can see that there is solid encouragement around the world from the judiciary to support this process. And I must say, I think it's a very efficient way to resolve disputes during the project, using people with some legal knowledge and some technical knowledge, hopefully to keep the project going. Anyway, that was all I had to say. So, Paul, if I can hand back to you. Thank you very much.
Good, thank you very much, Nicholas. We will now go to Festus, who will talk about the key characteristics of an effective adjudicator. Welcome, Festus.
Thank you, Paul. My presentation, as you can see, I don't know if it's on the screen. I think they have not put it on the screen. I had put it in 4 parts. The first 3 parts, Nicholas has really dealt with them very efficiently, and I don't want to belabor them. So I'll go straight to what would be the key characteristics of an adjudicator. There are many, but I have identified the following. 1, the adjudicator. Okay, I can see it's on the screen. Move down. Move down. Down. Go on. Move on, please. Yes, there. The first one I've identified is that an adjudicator must be aware of the existence of uncrystallization of a dispute. He cannot start on something that he is not sure that does exist. So he must be sure that it does exist, the dispute does exist, and it has been crystallized. Secondly, he must have obtained the authority of both parties to make a decision on their behalf. This is important. It's like offering jurisdiction to an adjudicator. He cannot act without jurisdiction in the matter. So an adjudicator must have the authority of both parties to make a decision on their behalf in the disputes. The third characteristic is that the adjudicator must ascertain that the parties have made attempts on their own to have the dispute resolved amicably. If they have not done made such an attempt, the adjudicator is free to advise them to attempt to arrive at an amicable resolution, so that is sure that he is going ahead when a dispute does really exist. Down the page, please. The fourth characteristic I have identified is that the adjudicator must agree with the parties on the procedure to be adopted in the process. Such procedures need to have been defined in the contract between the parties. The fifth characteristic, Paul, that I identified is that an adjudicator must ascertain from the parties to the contract that indeed there does exist a dispute. Aspect of adjudication is that the adjudicator must ascertain that a written notice of adjudication has been issued by the party that is aggrieved. This is very important. There must be such a notice for the adjudicator to embark on his process of adjudication. He needs to ascertain that the notice of adjudication has covered the salient points of the dispute, such as the date and details of the contract between the parties, the issue or issues the claimant wants the adjudicator to make a decision on, the nature and extent of relief the claimant is seeking, a statement that the dispute referral procedures in the contract have in fact been followed and complied with together with the period of notice. Down the page, please. The other characteristic is that the adjudicator should ascertain that he has the complete referral document or documents with him prior to proceeding. He cannot rely only on the notice of adjudication. So he needs to have all the documents in his possession. The next characteristic is that he must exercise total impartiality during and after the process. And he must give equality to both parties throughout the process. And in doing so, the adjudicator must observe the rules of natural justice, just like Nicholas pointed out in his presentation. It's important that he must appear to be neutral, to be fair, and to have no bias. The adjudicator must, as indicated before by Nicholas, keep within the timelines that have been provided by the contract, and he must deliver his decision as stipulated in the contract. He must also be a keen listener to both parties and must fully consider all the issues and presentations made by the parties without appearing to have any bias or a favor. Down the page, please. The adjudicator should provide a reasoned decision at the end, even if this has not been preferred by the parties. This would actually obviate any misunderstanding that may come later. So it's important that this aspect of the decision making will obviate in the minds of the parties any doubts in the decision of the adjudicator. The last characteristics that I identified is that he or she must be able to disclose if she has any interest in the matter. This is very important because it exudes a lot of confidence in the performance of the adjudicator. Paul, I think that is all that I could identify on this matter. Thank you very much.
Thank you very much, Festus, for your very detailed presentation. I will now invite Mr. Bwalia to make his presentation. Mr. Bwalia, as you are aware, in Kenya, we refer to engineers and quantity surveyors by their profession. Like I should be referring to you as Engineer Lumbwe and Mr. Ritiku as quantity surveyor. Festus Litiku. Mr. Balwa, please.
You're on mute.
You are muted. Please unmute.
Unmute, please.
Yeah, sorry, I heard all what you said. I was just saying that you can clearly see the difference between engineers and quantity surveyors. All of you are wearing ties. And jackets. I would like to share my thing. Let me just find my presentation. Where is it? Let's see. Right. Is it visible now?
Yes, it is indeed.
Yeah.
Right. Okay. Except now that parts of it is covered by. Let me move this. How do I do that? Okay, right. Okay, right. Thank you very much, Paul, for the introduction. And also thanks very much for the other presentation. Some of this presentation will look as if it's repeated because it's been mentioned by all three of you. So my topic for today is basically COVID-19 and construction education. The word education, I think, has been defined quite well by Paul. It includes your normal education plus the DABs. Right. Okay. Except for essentially construction activity, like other sectors of the economy, had virtually come to a standstill in many jurisdictions due to the COVID-19 pandemic during the earlier part of the year. As lockdowns lift and the construction industry scales up, issues will arise that the parties will need to resolve. Many of these issues stem from work suspension, time delays, and costs, and most will be resolved by the parties based on contract terms. And a good number will result in claims and disputes to be resolved in adjudication. Take note, however, that there are jurisdictions which have statutes providing for pandemic situations. The resumption of work is likely to be disrupted due to pandemic health regulations such as PPE requirements, that is personal protective equipment requirements, social distancing, and regular cleaning of surfaces, which may well result in claims. There are other regulatory requirements as well in most countries. Other disruptive effects, as Paul mentioned, may result from a shortage of materials or equipment, as suppliers are equally affected by the lockdowns, again resulting in claims. Skilled labor, which Paul mentioned as well in his introduction, may also not be available due to travel restrictions, particularly on large and international projects. Some of these claims will undoubtedly result in disputes leading to adjudication. The pandemic has not only changed how construction work is performed, but also how claims, disputes, and thus adjudication are dealt with. The major change is the increased use of digital technology for hearings, meetings, document transmission, and communication, as we are doing now. Meetings and hearings are mostly being carried out by virtual or video conferencing platforms such as Zoom, Google Meet, Microsoft Teams, Skype, WebEx, or GoToMeeting. The UK's Technology and Construction Court, TCC, is a good example of intervention providing guidance and directions for the resolution of construction education in the age of the pandemic. Neocris Developments Limited versus Waters established a principle that parties cannot rely on the unprecedented circumstances caused by the pandemic to avoid adjudication. The court ruled that difficulties resulting from COVID-19 were not valid reasons for parties to avoid participating in adjudication proceedings. The court also pointed out that parties had to work around the pandemic challenges given the adequate means of electronic communications or technological communications. As an example, the court stated that site visits could have been conducted via video link while reaching potentially unavailable witnesses via the same means. Except for essential work, construction activity like other sectors of the economy. I think I've gone backwards. Right, okay, there we are. The pandemic has not only changed that, again, I'm on the wrong, right? Okay, there we go. Sorry about that. Another case is Brosley London Limited versus Prime Asset Management. which demonstrated that while cash flow will undoubtedly be a problem for many companies during the pandemic, the court was not prepared to allow Adjudicate to deviate from its primary purpose of facilitating a pay now, argue later regime, which I think all three parties before me mentioned. The court's message of business as usual meant that adjudication proceedings needed to adapt, and as such, a new way of working was needed. I see the TCC's lead being followed at least in most of the common law countries. Most adjudicators and parties are rapidly settling into a new way of working, allowing them to continue to function in these exceptional circumstances. I don't know why that is red. I've got a few red marks. Let me just change that. So the new normal proceedings consist of remote site inspections, which is the use of videos and video via drones or movable fixed cameras. Remote meetings and hearings, use of video conferencing software or platforms is now common. Electronic filing and bundling. This is a new normal through email and data report sharing platforms. In construction, I think most of you know that cash flow is king. So a smooth functioning education procedure is important. Paul and I think all the other parties also alluded to this. This means adapting to the new normal as a result of the pandemic. Therefore, adjudication is even more essential, and the flow of money in construction activities will be one of the keys to getting back on track. Take note that most standard international good contracts will have a force majeure or similar clauses. Force majeure simply means an unforeseen event that prevents a party from fulfilling a contract or parts of a contract as planned or as contracted. Effects of COVID-19 are probably a force majeure event for most contracts. To repeat, COVID-19 is likely to result in work stoppages, suspensions, cost increases as a result of social distancing, personal protective equipment requirements, delays in supply of materials, delays in getting certain site expertise. Successful claims and disputes to be resolved by adjudication will still require adherence to contractual requirements, such as the issuance of valid notices of claim. A valid notice may be a condition precedent to accessing a claim, and that's an adjudication. Pandemic health regulations have in many instances resulted in difficulties in carrying out work. This, however, does not mean that such work should not be carried out. In many instances, however, a change of method will get the work done. The principle of mitigation still applies even under a pandemic situation. Recovery of costs and time will lie in the disruptive effect of the pandemic in most good contracts. Tips for virtual proceedings. Training. Adjudicators and parties should practice the use of technology before meetings so that they are comfortable with the platform, as platforms have different features. We actually did this yesterday as a panel. Flexibility. Adjudicators expect the parties to act reasonably, work collaboratively, and make allowances for pandemic environment. Difficult parties may face sanctions. Hearing protocol or rules. Pre-agreement of a protocol for the hearing helps to remove some of the uncertainty and lets everybody focus on important issues. The protocol rules should deal with timings, documents, hard copies or electronic, logistics, who is host, who is sending the invites for the hearing, attendees, technological matters, which mics and cameras are on and which are off, and costs of both of any platform or additional services such as e-bundling. Documents. Electronic bundles, reports, and other records need to be easy to navigate with clear instructions on accessing and the use of documents, as some people will not be familiar with the technology. Technical issues. Preempt technological challenges and take steps to minimize the impact. This is interesting because I couldn't find the link to this meeting today. I had to ask for it again. This is one of the issues. And I should have had a phone to phone up Nairobi, but I couldn't find that phone either. So that's a good example of what can go wrong. Don't leave submissions via email or data sites to the last minute. Plan ahead. Carry out a test or trial setup for any hearing meeting. As I mentioned before, technology differs. So you may be using Zoom one day, you may be using GoToMeeting the next day. So just make sure that is done. Protocol agreements or rules should take into consideration what happens should things go wrong, which I just mentioned. Who does the affected party contact mid-hearing meeting if they drop off the virtual platform? Site inspection videos or evidence may be large and not suitable for virtual hearing or meeting platforms. Hence, consider the use of large format sharing platforms such as WeTransfer or Dropbox in lieu. Also, consider the effects of video conferencing fatigue by having breaks limiting the day's meeting or hearing to about 4 hours, which is just a rule of thumb. 2 months ago, I had a class thing with the Lagos Court of Arbitration, and we were going for 3 hours every day. And after that 3 hours, I can assure you, I was fatigued. It is not the same thing as teaching in person. In ending, the COVID-19 pandemic will continue impacting construction for many more months or years to come. Undoubtedly, there will be other epidemics and pandemics in the future. Hence, the use of technology in education is here to stay. So, adapt or die. As I finish this presentation, I leave you with this quote by Tomasi di Lampedusa in his book, The Leopard. If we want things to stay as they are, things will have to change. Let me just repeat that again. If we want things to stay as they are, things will have to change. I urge the participants, therefore, to adapt this thought in the context of COVID-19 pandemic and construction education. Paul, thank you very much. That's the end of my presentation.
Oh, welcome, Balia. I must say I also had challenges tracing the link for this webinar. So Balia, you are not alone.
Thank you.
Yes.
Right. Yeah.
Now we come to the question and answer session. And the first question is from Mr. Sanjeev Kagram. He is a Kenyan advocate, also involved in construction, adjudication, and construction projects. The question is twofold. Firstly, what remedies are available where a DAB fails to discharge its mandate within the agreed constructual period? Nicholas, you talked a bit about that in your presentation. Would you like to expound as a way of answering this question? That is the first aspect of the question. The second one is, what is the effect of a decision which is issued past the stipulated time? Please proceed, Nicholas.
Okay, so I'm taking this to mean that even if the parties have agreed additional time, because it is possible for the adjudicator and the parties to agree time, and some of the rules even provide for that, but assuming that the decision is still late, then it seems to me that the decision isn't a valid decision. And this is really, you know, I think very important. The basis of all adjudication procedures is contractual. It's what the parties have agreed contractually. And if there's a deadline for service of the decision, then it would normally be that both parties and the adjudicator can agree to extend it. If then the decision is still late, it's not a decision that's been issued in accordance with the contractual arrangements between the parties, and it's not a binding decision. There are some cases that cover this. In England, for a little while, it was thought that the rules produced could allow the adjudicator to extend time similarly to arbitration, but that was found not to be right because there isn't a legislative backdrop that allows that to be done. So with arbitration, there are powers within the legislation that allow arbitration tribunals to do that. There isn't with adjudication. And then secondly, it was also thought that maybe provided there wasn't a fresh adjudication but the first adjudication was late, it would still be valid. But the judges have made it clear that that's just not right. It's just not logical. So in other words, if a decision is given late, it's of no standing. And I suppose the problem there is it means that the adjudicator, it's one of those rare situations where the adjudicator can be in breach of their duty to the parties because they are obliged to deliver it on or before the deadline.
Good, thank you very much. Engineer Balwa, would you like to add something to that?
No, I think Nicholas has covered the question quite adequately. It's exactly the same. I think it will not be valid at all.
Okay. Okay.
Yeah,
good.
unless parties agree otherwise.
Okay, thank you. Sajiv, I hope we have answered the question to your satisfaction. We will move to the next question. What are some of the challenges you have faced as a construction adjudicator in Africa? And I think I'll start with Festus.
As pointed out in our presentation earlier, we do not have legislation or statutes covering adjudication in most countries in Africa. And even here in Kenya, we do not have such legislation. So you find that the difficulties I've noticed is that the parties don't seem to be very agreeable to adjudicators because of two reasons. They think that adjudicators do not work, but they earn a lot of money. So if they can be avoided, it's very good. I was involved in a case where my name was there, but I was not involved. I tried to find out why. That we have no disputes. Why should we pay you for doing nothing? So that is a challenge we find in Africa, one of the challenges. But it's mainly because we do not have statutes to protect adjudication in Africa. Thank you.
Okay.
Can I just add something as well?
Yes.
Yeah. I mean, one of the problems I find in this region as well, Zambia, is that the 28-day period is not well understood. You have parties who bring in teams of lawyers into an adjudication who always their first core business is to extend and extend and extend. And I think statute, as Festus has mentioned, would resolve that problem. And as I said, lawyers, parties, for some very strange reason, are not confident. They so always bring lawyers. And that is a problem. Thanks, Chair.
Should I may just make a brief point?
Yes.
I do. I mean, I'm dual qualified. I'm a chartered surveyor and a lawyer, and I do understand that problem sometimes, where perhaps a party doesn't really know what is happening to them. You know, they've had their first experience with adjudication, so they go and get their engineers and their lawyers to try and help defend and whatever. And so there may be some misunderstandings there. But also, I think we must remember, if we are an adjudicator, we have to robustly deal with whatever a party puts to us. And sometimes, of course, if a party is claiming from the other party's mandate to its team, including its lawyers, might be, I don't want to pay this. What can you do to extend time and do it? And then that's what they're being paid to do. And there's nothing wrong with that. That's life. But I think we must remember as adjudicators to robustly deal with it. And I do have situations where you can see this is happening and you set out a deadline and time scales and you say, that's what I want to hear from you. And that's when it's going to happen, because you must remember as adjudicator, you're in the driving seat. So be bold and be brave.
Well, thank you, Nicholas, for being honest about the kind of instructions solicitors get from their clients.
But this is true, yeah.
Now, I happen to have served as a member of the Public Procurement Administrative Review Board in Kenya a couple of years ago. And we had 21 days from the date of receiving an application to the date of giving a determination, 21 days. And without fail, we always complied within, we always gave a decision within that period. We were aware of the time limitations, the parties were aware, and so the system was streamlined to work very quickly in order to give a decision within 21 days, all the time, without fail. And I want to comment on what Barrier has said and Nicholas has added onto. With or without a statute, if the parties and the adjudicators know that they have 28 days, why would they not all work together to achieve that? And of course, the adjudicators are on the driving seat. As Nicholas says, the adjudicator or adjudicators should be brave and firm. So why is it that our adjudicators are finding it hard to comply with the 28-day limit? Festus, would you like to comment?
Paul, thank you very much. I can cite my personal experience where I was involved in adjudication. And as our two other presenters have said, the parties tend to come loaded with their lawyers, and they come with applications for expansion of time. So you find that whereas the contract expects you to deliver your decision within a specific period of time, the parties frustrate that through their lawyers and their applications. That's what I've found. So even if you want to impose your own timeline on them, you find it's very difficult to do that. I found it very difficult. Thank you.
Now, you're not off the hook yet, Festus.
Yes.
Because we are trying to blame lawyers, and yet, as Nicholas says, sometimes they are doing exactly what they are paid to do. Why isn't the adjudicator doing what he is paid to do, which is to give a decision within 28 days? Now, I must say that even at that board, which I mentioned, parties came with lawyers and with lots of stories, but we somehow managed to always give a decision within 21, not 28 days. Over to you, Festus. Please comment on that.
That's a compliment on your part, but I was telling you from my practical experience, I found it extremely difficult to bulldoze a timeline to the parties. I don't know what we can do about it. Maybe we can learn from our friend Nicholas what they do in the UK.
So if it, I mean, occasionally we have these huge complex disputes that need resolving in 28 days, and the parties will ask for further time. And I always remember that if they want more time, so do I. And if they propose a timetable requesting time, I usually go back to them saying, well, okay, I'm happy to take this further time that you will want, and here's the extra time I want. So the decision will be delivered on that date. And there's your choice. We can all agree it, or you can have submissions in 3 days each rather than the 10 that you want. And that tends to work. And the other thing to remember is that and this was taught to me by a long retired engineer in England when this first started. He said, you know, if the parties won't agree anything helpful and they give you too much information, you can always threaten to resign. And there you are at day 20 and they're bombarding you with information, they're ignoring the timeline. You can say, this is very complicated, I'd like to agree a deadline for my decision, or I'll just resign, you can start again. And I've never had to do that, but I've seen him do it and it definitely works. Because then, you know, they're going to have to come back and start again. And the other thing about the appointing bodies, certainly in England, is that they tend to always appoint the same adjudicator again. So We know that now, but there's much more reasonableness now, having had it for 20 years in the UK. People do tend to agree sensible timetables, because of course the other thing is that there's only one of you, and they want you to read what they're giving you. And how do you do that if they aren't giving you enough time?
Good, thank you very much. Barwa, I'll ask you to comment, but I'll tweak the question a bit. And I'll be asking you, are the 28, 56, or 84-day periods within which adjudicators must issue their decisions reasonable during the COVID-19 era?
Well, from my point of view, I think it's quite reasonable. I mean, as long as parties can use technology. I think one of the cases I mentioned, in fact, I think the court was referring to such a thing. I don't see any problems to do education within 28 or 56 days or 84 days, but the parties must use the technology that is readily available now. I really don't see any problems. And I've actually had to do, I think I've done 2. Just like that. But the parties must understand that just because there's COVID, right? And as Nicholas said, you have to be firm that you're not going to be extending time unnecessarily, unless there's very good reason. And I haven't had any example of that to extend time. But otherwise, it's all been done within the specified period of time.
I hear you, Balia, but
yeah.
I would like to press you a little harder.
Yeah.
I'm based in Nairobi. You are in Zambia.
Yes.
Supposing I needed a construction engineer for a project in Nairobi.
Yeah.
To come and resolve a dispute which has arisen.
Yes.
And this is during the COVID-19 era. You know the restrictions.
Yes.
In Zambia
travel restrictions. Yes. Yeah.
Yes. Do you think you can perform within 28 days? Well,
in that case, there's good reason because you're not, unless if the adjudication is going to be based on an inspection and other things where the engineer or the adjudicator has to physically come and inspect something, then of course in that situation, no. But where it is based on paper, right, that could easily be done.
Okay.
If it's a paper-only adjudication, I see no problems at all. And the ones I've done, and thanks for bringing that up, are all paper-based. I didn't have to go through the process of going to the site. But on the other hand, it may be quite possible, although a bit tricky, to get evidence sent to you by video, right? It's not the best, but for small cases, I think where you don't actually need physical process, that may be sufficient. There's a lot of video usage now in construction sites. So that may be one option as well, where the case is simple and you can see the problems on video. It is not always possible that you see the problems yourself and appreciate them unless you do a site visit.
Okay,
yeah.
Thank you. I'll ask Festus for his comments about that. The question, Festus, is whether 28, 56, or 84-day periods are reasonable in the COVID-19 era.
I can say yes and no. Yes, because we have adopted technology on most of the projects we have working on. And we've seen that both the engineer and the contractor have worked very hard to perform within the timelines. Where we have parties who do not have this knowledge or expertise, we have problems and big challenges. It's both yes and no.
Okay. Now, Nicholas, what is your experience with respect to these very tight time limits in the COVID-19 era, which is characterized by health and travel requirements, including lockdowns?
Yes, I think that when the COVID lockdowns first happened, everybody was trying to work out what to do. But I think they've settled down fairly quickly into working in this virtual world, and there is a chance to be more efficient in fact. And I've now had quite a few case management meetings, hearings, and even virtual site visits now using virtual systems. So on one project where I sit on a dispute board, and we have had many site visits in previous years, it hasn't been possible this year, but we've had 2 virtual visits, and that was done by everybody logging onto a virtual system and receiving PowerPoint presentations with photos and so on. And also we've also seen drone flyovers of projects. And in relation to hearings, I had a hearing a while ago. The project is in Africa, and parties were in Africa, Italy, France, England, and a couple of experts from America. And despite the time difference difficulties, the hearing went on for several days and worked very well, and that saved everybody traveling and the cost. And I do think that where you've got international projects, it's really important to have a site visit if you can, but also if it's not really possible, then there is a saving to be made by conducting any meetings or hearings virtually. There's less carbon footprint, and I think everybody's now got the technology and is used to it. So I think it might be here to stay, regardless of COVID.
Good, thank you very much. Now, we have a comment here from Peter Pakuto of Uganda. He is in charge of construction adjudication at Uganda Institute of Professional Engineers. He says our challenge has been lack of adjudication legislation. Most parties bring advocates, yet an engineer adjudicator is appointed as a technical person. So you have an engineer who is appointed as an adjudicator, but the parties, instead of bringing technical people as their representatives, bring advocates. What are the issues arising in such adjudications?
Well, I mean, can I just perhaps answer? I think I referred to my answer previously. The first core of business for lawyers is they complicate matters, right? And ask for postponements. That is usually a problem. I always try and convince parties when I teach some of these things that, look, you can do it as an engineer or as a quantity surveyor. In fact, you'll be able, you'll be much better, you do much better in understanding what the problem is. But I think education is a key. We need to start educating the contractors as well as the consultants as to what the advantages are in construction education.
Yes, Nicholas.
I was going to say, I think it's really important for everyone to remember that with construction issues, there is always, with an adjudication, there's always 3 things going on, 3 huge areas. One is the procedure, what to do, timing and wise and so on. The other is the contract. What does it say and mean? What's the legal interpretation? But you can't get away from the most important one, the third one, which is what's going on technically and factually. That's the thing to always remember, is what is happening on this project. And a lawyer's job might be to try to defend their client and hopefully not pay anything, assuming that's always what a defense's position is going to be. But they can't get away from the clear facts of what is going on. And the great thing about having a technical background is that you should be able to understand that and then apply your judgment to just see through the problems and come up with a fair outcome and not be too waylaid by many of the technical or apparent technical difficulties. But of course, you do have to be aware. Sometimes they might be right. The real reason might be some clear term in the contract, and that prevails. And we have to sort of try to use our judgment as adjudicators to work out what really is going on. And it is a challenge because you have to weigh up your legal knowledge and your technical knowledge.
Yeah, thank you, Nicholas. That takes us to a slightly different perspective, and that is of this the solo construction adjudicator, who is a solicitor with no experience in the industry, not somebody who is dual qualified like you, but I'm talking of a solicitor who has not been involved in construction, maybe trained in arbitration, in adjudication, in law, of course, but not in technical areas. What is your experience regarding such a person playing a role as a solo arbitrator?
I've seen some really good ones that have spent their life working in the industry and have come to understand it. And what they'll tend to do is look at the parties' experts or listen to the people explaining technically what has happened and carefully use their skills to weigh up and judge what they think is honest and right, and then make a decision. And I've seen some do there are definitely people out there doing excellent job at that, and they're truly, you know, providing justice well. There are others, I think, that struggle a bit to understand the technical side and get lost very quickly. My only advice to them is to rely on the parties' experts and question them. And if there aren't any parties' experts, then consider appointing someone to help you yourself. It would depend on the rules, but it is often possible to appoint a technical person to help. You have to be careful about what skill you need. It might be a quantity surveyor to look at the figures if it's all about quantum, or it might be an engineer if it's to do possibly with the methodology and delay aspects or some technical things, and can be difficult to pick your expert. But don't get caught in the headlights and panic. And I think we sometimes forget that these, you know, it's frustrating if you're one of the parties and you can see this happening, but it's also difficult for the sole person in that position to know what to do. But yes, I think it's difficult. And this is one of the reasons why DABs, if you have three, then it's good to have a mix of skills. It's no point having three engineers only. It's better probably to have an engineer, a quantity surveyor, and a lawyer. Then between them, they should have the skill set, and often that isn't always achieved.
Good, thank you. Festus, what is your experience?
Our experience has been that we have, on a number of our projects, had a mix of the professions. And my experience is that we have not had lawyers on the DB, although we have had lawyers from the parties. But it has gone on well because we have had engineers, architects, quantity surveyors, and such mix. It has been good for us.
Good, thank you.
Thank you.
Valia, would you like to comment?
I think we've been well covered. Thanks.
Okay. Now, I have a comment here from Engineer Alwatch saying, I like the response from Festus regarding lack of legal framework. So in the absence of legal framework, what's the future of adjudication in Kenya and in Africa generally? Who would like to give a shot at that?
Well, I can go first. I mean, in Zambia, for example, I think there is case law where the courts have, parties have jumped the adjudication process, because it will usually be adjudication and adjudication followed by arbitration, and then, of course, the last litigation for setting aside the proceedings. But where parties have tried to jump from adjudication to some other process, the courts have actually sent it back in support that you have to go through that first step, because it's a condition precedent for you to take any other action, arbitration or whatever that is in the contract. So there is support, at least from the Zambian angle, from the courts, so to say.
Okay. Now, Festus, what do you say about Kenyan court?
In Kenya, we tend to rely on the stipulations of the contracts, and the courts will listen to that. But the Institute has developed a draft act for adjudication, and I don't know whether it has been subjected to public debate, but I understand it is somewhere, maybe in the AG's office, awaiting enactment. But I still think that we need to subject it to public participation before we finalize it. I don't know what's happening in the rest of Africa, but I believe they depend on the provisions within the contract and work on that.
I would like to comment, Festus, because I'm familiar with that draft of the adjudication bill. And I would like to make a comment just in case the AG's office comes out in bad light. CIAB Kenya branch drafted a bill, but it subsequently withdrew that bill from the AG's office where it had been presented for further consultations. So as we speak now, as far as I know, there is no outstanding bill at the AG's office, which that office has not dealt with. Now, Nicholas, would you like to chip in?
Sorry, in terms of
the future of adjudication in Africa in the
with legislation, or yes, okay. So, yes, it's interesting, isn't it? Because you see from the court decisions that it seems to be working quite well as it is. So why change it? But of course, the reality is that in England, we had contractual adjudication, which worked to some extent before legislation, but was not really used. But I think that the benefit of legislation is twofold. First of all, it then encourages everyone to use it because it's there, and in England we have to use it. So it means that people know that this is the new game in town, as it were. Adjudication is there. And secondly, it gives you a clear set of rules. People know what they can and can't do, and the judges know how to enforce and deal with it. So I think there is a great benefit in legislation that applies fairly and evenly to everybody in a particular country. And it would be great even if different countries are able to almost copy each other. So the English legislation was pretty much copied in some Australian states, but in other Australian states they have a different process similar to Singapore. And I know it's important for each country to do its own thing, but when it comes to construction, the problems are the same the world over. And if there's commonality of approach, that's got to help the international contractors, international consultants that are working in different places, and just make it more efficient and easier, I would have thought.
Okay.
Yeah.
Yes,
can I just add on? I think something that is very important. I mean, I used to sit on the Zambia Public Procurement Authority Committee for about 7 years. And one of the things that the Public Procurement Act does is that it standardizes, right, contracts. So you got, we use the FIDIC Pink Book for large contracts and the World Bank forms of contracts. Right now, the law behind that, right, requires everybody to use, right, those contracts. Now, under those contracts, like the small works contracts, I think Kenya is probably the same, Rwanda is the same, but Zambia is slightly different because it's then supported by legislation, which states that you cannot change a contract, right? So you cannot amend a contract, right, without the authority of the Attorney General. So in other words, if you try and jump the adjudication step, right, you are in breach of the law. Right? So you cannot just change it and ignore it and move to arbitration or go to the court without the authority of the Attorney General. So that indirectly actually is a legal framework that supports adjudication. Although in Zambia, we are just at the beginning now of trying to do a statutory adjudication.
Good, thank you very much. Yeah. Now, Engineer Edward has also asked us to put construction adjudication in the local Kenyan or African context. And I think we have done that very well already. So I'll move on to the next question. Is it necessary to have construction adjudication in a project which also provides for an emergency arbitrator? Is there a duplication of roles here? Is it necessary to incur money, incur costs, both in an adjudication and then an emergency arbitrator? I'm not even talking about the main arbitration, just the emergency arbitrator. Nicholas, please.
Yes, so just thinking back to when the emergency arbitrator was first introduced in the ICC rules, and the rules are still the same in this respect. It says that well, there are certain provisions about when you can actually go to an emergency arbitrator, and of course the purpose is for some substantial, immediate, and an important relief. The ICC rules say that one of the other jurisdictional requirements to get to an emergency arbitrator is whether the contract already provides a fast method of dispute resolution pre-arbitration. And it's always been thought that where you have a DAB, that then you can't use an emergency arbitrator under the ICC rules because they already provide a process. I've not seen that played out fully, but that's certainly been how it's been interpreted. Some other emergency arbitrator rules are a bit broader, and it might be arguable that the emergency arbitrator is still a possibility, but I think it will be difficult, because if you've already had quick adjudication relief, I don't think the emergency arbitrator is there to repeat it. And most emergency arbitration rules provide that the emergency arbitrator is there not necessarily to make a payment, and usually adjudication is about payment. Usually emergency arbitration is for some other important relief, such as access to documents or access to site, rather than a payment of money. So I think they probably interpreted correctly. If you look at the contract and the applicable arbitration rules, you'll probably find there is a pathway between them, but it may not be immediately obvious to spot.
Have you got something to add, Balwa?
No, nothing at this stage.
Okay, Festus?
Not much, Paul, but by its nature, adjudication is supposed to be interim, and I don't see the need for an emergency arbitrator coming in, because they'll be duplicating costs and time.
Okay, yeah, thank you. Now, I would like to give you a hypothetical scenario. A new airport to be constructed, completely new from scratch. And there are several contracts and subcontracts in place. Would you recommend a separate adjudication panel for each contract and for each subcontract? What are the options? Nicholas, please.
Yes, it's a good question. I think that when you have a very substantial project with many packages, and airports are a very good example, there is an opportunity there to think about how you structure the dispute resolution procedures. And so I frequently see large packages let on a FIDIC type contract with its own dispute board potentially attached to that package. And sometimes they're not appointed at all until there's a dispute, and then you end up with many dispute boards running with different people on them. Compare that to a centralized dispute resolution procedure to which all of the package contracts refer. There was a process like that on Terminal 5 many years ago. That was a £4 billion English pound project. And they had an NEC-based contract, but they had a dispute resolution procedure that was multi-staged, and that involved negotiation and something called a star chamber, which was where very senior representatives came together to try to solve it before it went on further. So that was a great idea. And currently I'm sitting on a large project where there is one dispute board and there are multiple contracts. The dispute board has 5 people on it. And I'm the chairperson, and this means that we've got the benefit of 2 different engineers, an architect and a pure lawyer. The idea being that if there is a dispute, then we can select, and there's a mechanism for selecting the most appropriate 3 people out of the 5 for that particular dispute. So if it's heavily engineering, probably 2 engineers and maybe me or the lawyer. If it comes later on and it's about the buildings, maybe the 1 engineer and 1 architect. We can also consider whether it's very legal in nature, the dispute, or very technical. And I think that's quite a good idea. I think that's probably one of the best ways to do it, probably more economic than having a dispute board for each of the packages. And it allows selection at the start and site visits. And I'd encourage that approach. I think it's the best approach.
Incidentally, the construction of the channel or of the railway bridge between the underwater railway bridge between England and France, constructed a few years ago.
Yes.
Were the dispute boards conducted in English or French?
Well, English. But of course the law applicable was English and French. So basically they had to decide on a commonality of approach. So a lot of time was spent doing analysis on English and French law and looking at how different they were. Interestingly, most legal systems seem to come to the same answer. The pathway is different. And on this project that I'm working on at the moment, it sits between 2 countries, and there are 2 different legal systems in relation to the project because it spans 2 countries. I think it's again on this one the language is in English, but 2 different legal systems apply, neither of which are English. So you can achieve anything by contract. It just creates. It can create a lot of work if the parties haven't thought about the implications of having 2 legal systems. It seems easy when you're negotiating just to accept 2 legal systems, but this means when there's a dispute, there'll be quite a lot of argument and analysis about which particular rule applies and what the differences are and how you select one or the other. Fascinating for the lawyers and possibly the academics amongst us. But all created by not going down one pathway at the start. But this is the difficulty with mega projects. It's, they're political, there's huge funding. It's very difficult to sometimes come to clear decisions about what to do. But having an efficient dispute resolution procedure that can make interim binding decisions on these big projects, I think is exceptionally helpful for everybody involved. And it has been on the increase for the past 20, 30 years. And hopefully we'll see more of it because I think all the participants benefit.
Good, thank you. Now we have 3 more minutes, and within those minutes, I'll ask Festus to make closing remarks in just 1 minute. Just 1 minute, please, Festus.
Paul, thank you very much. This has been a very very fruitful meeting for me to meet colleagues from across the countries, the borders, Nicholas and Valia. Is it Wala or Walia?
Walia.
Walia.
Yeah, Walia. Yeah, oh, Nicholas, yeah, that's good. If you speak French, Nicholas, it's easy to pronounce, do you?
Badly. No, not really. My French is dreadful, I'm afraid. A
Because,
typical Englishman.
The vernacular, AEO, is similar in French. It's AEO.
So I would like to thank you for the opportunity, to thank the participants, to thank Nairobi Center for International Arbitration for giving us this opportunity. We hope that we shall have more in the future, and I wish everybody all the best. Thank you.
Good. We still have 2 minutes. Badia, half a minute,
Yeah.
please. Final comments.
Perhaps mine is just an appeal to construction professionals. You know, adjudication and arbitration is becoming complex by the day, and we need more professionals to train in construction law. There's a shortage. That's why sometimes we end up with lawyers doing all these things, because the professionals don't take up the challenge of learning the law. And I think it's absolutely necessary. In this day and age, you cannot do with just your basic education, particularly for more complex projects. Thank you.
Well, we have half a minute. I need not say more, but I'm really honored to have chaired this panel. Thank you very much.
You haven't let Nicholas put in his last word.
We're out of time.
Well, I deliberately allowed him to take more time a little earlier on.
Okay.
So thank you very much, gentlemen. It has been a pleasure being with you in this webinar, and I wish you all the best in your endeavors. As for the participants, thank you very much for attending this NCIA webinar. Watch out for our other webinars. They will be announced shortly. All the best. Asanteni sana. Bye.
Bye.
Thanks very much.
Okay.
Goodbye.
Bye.
Have a good day.
Bye.
Bye.